5 seconds to go. Start. It has already been discussed in detail that the suit property is the absolute property of the defendant. From the evidence given by the defendant DW1, the court can very well come to conclusion that the entire transaction is based upon an oral sale agreement emerged between the plaintiff and defendant. Further, the plaintiff has shown his readiness and willingness to perform his part of the contract. Therefore, viewing from any angle, the contentions put forth on the side of the appellant's defendants cannot be accepted. Mr. Krishnan Venugopal, learned senior counsel, appearing on behalf of the appellants, argued that both the trial court and the high court committed an error on facts and also in law. According to him, the issue relating to readiness and willingness on the part of the respondent plaintiff had not been properly appreciated by the courts below. Emphasizing on section 16C of the Specific Relief Act 1963, Mr. Venugopal submitted that the respondent plaintiff had not adduced any evidence to demonstrate continuous readiness and willingness which the respondent plaintiff was required to prove regardless of any default by the original defendant. Mr. Venugopal also argued that the court should also take judicial notice of the steep rise in the price of real estate before granting the discretionary relief of specific performance. Mr. N.D.B. Raju, appearing on behalf of the respondent plaintiff, submitted that the issues framed by the trial court of whether there was a concluded contract between the plaintiff and the defendant and whether the plaintiff was always ready and willing to perform his part of the contract were factual issues determinable on evidence. Mr. Raju argued that this court should not disturb the concurrent factual findings of the trial court and the high court of readiness and willingness of the respondent plaintiff to perform his part of the contract. Mr. Raju has emphatically argued that the respondent plaintiff was ever ready and willing to perform his part of the contract and that the original defendant had been delaying the execution of the sale deed. To prove readiness and willingness of the respondent plaintiff, Mr. Raju referred to the testimony of the plaintiff's witnesses PW2 and PW3 who have stated that the respondent plaintiff had on multiple occasions before the cutoff date of 15th March 2003 approached the original defendant for execution of the sale deed, but the original defendant delayed the execution of the sale deed. It is well settled that in a suit for specific performance of an agreement, it is for the plaintiff to prove his readiness and willingness to perform his obligations under the agreement. Where a certain amount has been paid in advance and the balance is required to be paid within a stipulated time, it is for the plaintiff to show that he was in a position to pay the balance money. The plaintiff has to prove that he has the money or has alternatively made necessary arrangements to get the money. In this case, the original defendant appellants have all along contended that the plaintiff respondent neither offered to pay nor was in a position to pay the balance consideration of rupees 15 lakh. Stop.